Yvette Valencia. She's an attorney at Valencia Law Now. Her topic will be on estate planning, so let's give her a warm welcome.
Good morning. Good morning. I have a handout and I'm going to explain a little bit, and today's main topic is not only going to be estate planning, it's about Medi-Cal. So my name is Yvette. I grew up in Hillside Village. It's on the other side of El Sereno in Los Angeles. I went to Sacred Heart Elementary School, Sacred Heart High School for 2 years, Francisco Bravo Medical Magnet, and then graduated from Cantwell High School in Montebello. So I was all over the place. I went to Pepperdine University for a semester. I quite didn't enjoy it, and then went to USC. Yeah, so that was really good. After I graduated, I was an English arts major. And people wanted to know, you want to become a teacher? And I was like, no, I want to be an attorney. I had an awesome advisor, and I had first declared a political science major. And they said, well, you want to be an attorney, right? Well, attorneys read, write, and interpret. So I suggest you become a literature major, and I did, and it was the best advice I ever took. So you give me advice, and if it's good, I'll take it. It's nice and sound. After I graduated from USC, I worked for Supervisor Gloria Molina out in the field. I worked for Councilmember Jackie Goldberg and the Los Angeles Community Development Department out in Hollywood. I got a little postcard in my mail, and then my goal was always to become an attorney. And I just did not know what kind of attorney. And I got a little postcard that said, become an attorney in 2 years. It's the only program in the United States where you can finish it in 2 years. So off I went to Michigan, Thomas Cooley Law School in Michigan, and I finished in 2 years and a semester because it got rather cold. I came back, and while I was in school, something happened. My parents have always worked. SC, most of it was paid by my parents. I think when I graduated, I only had like a $20,000 loan. And even back then, that was a lot. So when I was still in school, my father developed colon cancer. At that time, there was a law that said that if you had a pre-existing condition, you could not be insured. I don't know if you guys know, but the #1 reason for bankruptcy isn't credit card debt. It's medical. We don't have enough to pay our medical bills. So at the same time, my mother, who had worked as an interior decorator, sales, for over 30 years, a company she contracted for went bankrupt. All at the same time. So from having tons of money coming in, because we're working families, to nothing. My parents had apartments, homes, everything, all gone. My parents lived, and my father's healthy, but my mom was forced into retirement, and apartments lost, and because they didn't qualify for Medi-Cal because they were still underage, just quite, and then they had 3 homes, and they couldn't qualify. So, I mean, there's this book that I'm reading, and it's called God Winks. And it's like things happen in your life that kind of guide you, and sometimes it's mathematically improbable that things are gonna happen, and it's there. So sometimes these things happen to maybe give you purpose or different things in life. And so when you come out as an attorney, I don't know if you know, but you get to know everything, and it's called common law. You can come out and be an immigration attorney, a bankruptcy attorney, a criminal attorney. You learn a little bit of everything, and your job dictates you as to where you're gonna go. So all that was happening, and when I came out, that's how I ended up in estate planning and probate. Now I know that if my parents would have had a little bit of organization and maybe have done an irrevocable trust, they could have still kept the homes and qualified for Medi-Cal. Imagine that. So as I start my presentation, I want to tell you why I do what I do and what I love. I don't do divorces, I don't do bankruptcies, I don't do anything. I do estate planning. That includes a trust and everything else that we need to keep our families organized. And I also do part of the probate process when we don't get our stuff organized ahead of time. So in my office, I have a golden rule, and the golden rule is you do not transfer property to your kids during life. So one of the first papers that you'll have that's here, it's the new law that came, well, this one says on the bottom, it says 0619, but it actually came into effect January 1st, 2019. January 1st, 2017, and it's miraculous. Before that, people were transferring property to their kids all the time, and I'll give you my ugly story first. So people come in, even after they had a trust, I had a client yesterday, and they're like, I want to.
Everyone here in the back.
You can get your handout. If you didn't get a handout, we'll give you one. There's some all over the place. So what ended up happening, I had a client come in yesterday. She had a trust, and I did it maybe 10 years ago. And she said, but how about if I give it to my daughter? And I'm like, what you have in front of you is gold on paper. You don't want to give it. And I said, all of my work is through recommendations, everything. If you can't tell me who recommended you to my office, I'm very hesitant to take on new clients. But because what I do is serve people. And the example I gave to my client is I had the most disturbing call that I've had in my career. And it was like this: Yvette, I have a coworker of mine, and she is inconsolable. She's crying and crying. She was retired. She's a widow. She transferred her property to her only son, and she came to work at the hospital to clean just so she could get out of her normal routine and have human interaction, so she's working at the hospital. She just received a call, and it was from her daughter-in-law. I'd like to inform you that your son has just died in a motorcycle accident, and you have 30 days to leave. You do not transfer properties to your kids in life. Because the probate process, the son didn't have a trust. It didn't give a mom a life estate. Property goes to wife. Wife will then do whatever she wants. Ugliest call I've ever gotten. So we don't do that. There's all sorts of really good reasons to do it. Now, we go back to this Medi-Cal thing. So that first page is a new law, and it was updated June 2016. But if you just flip the page on the reverse, this is what people used to get, and they were scared to death. It says, when a Medi-Cal beneficiary is 55 years of age or older, at the time of death, those are scary words, at the time of death, the state will collect from his or her estate. So people thought, oh my gosh, as soon as I die, if I get sick, or people didn't get treatment because they didn't want to use Medi-Cal. Now here's another endorsement. If you receive Medicare, that means you cared enough to work. You paid into the system. It's not a government entitlement. If you receive Social Security, you worked, or else you don't get it. Now, Medi-Cal is help from California. It's additional aid. Medicare usually covers 80%. So like if our Medicare provider, we get glasses for $100, and Medicare covers 80, so they pay 80, we pay 20. It's okay. How about a heart attack? How about cancer? That's when sometimes people need Medi-Cal, and clients are like, oh, I don't want to use government help. And I'll tell my clients when they come into the office, the government does not work. If we have a Medi-Cal system, it's because taxpayers work and support that system. So in my belief is when we work and now we're retired and we can't work like we did before, we are entitled to that system that we put into. I'd be embarrassed if I didn't work and then I was taking, but that's a whole different story. So I tell my clients, if you have a house, use it. If you have a house, don't be afraid. We just have to organize. So with my client that came in yesterday, I said, you can use Medi-Cal if you're sick. You put into the system. And now the new law, so this old law, people would receive, so this is usually that famous yellow paper, and they receive this as soon as you return 55. And most people stop at that first sentence. At the time of death, the state will collect. Well, if you went a little bit down, right towards the middle of the page, it says, the department is not allowed to pursue repayment if the deceased Medi-Cal beneficiary was married. So that means if you have a husband and wife, husband dies, use Medi-Cal, they're not going to collect from the wife. But people usually got scared with the first sentence and stopped. The new law is way better. It says, so this is page 1. After a Medi-Cal member passed, so now you're a member, you pass away, the department may, it's not will immediately collect. It's now it may collect. And if you go, it says, if you're 55, the Medi-Cal, so when will they collect? The Medi-Cal member has real property or personal property and or other assets as of their date of their death, and that will be part of their estate subject to probate. Those are huge words. So how do you go to probate? With a will or without a will, you go to court. Probate means that you have to go to court. When do people go to court? When we don't take care of business or when we can't take care of business ourselves. What is a trust? It's a family contract. So if we hire a plumber, he charges us $1,000, $500 to start, $500 to finish. He does a really good job. We pay our bill. What do you do with a contract? Set it aside, you throw it away. That's a trust. If the plumber leaves with our money or we don't pay, what do? We have a contract to go to court. It's a second option. It shouldn't be your first. So what a trust does, it organizes families because every family is different. Every family is unique. Some families have kids with special needs. Some kids have families with older parents that we want to make sure that if something does happen to us, our kids don't, throw out our parents. Every family has different needs. Some have adult kids, some have younger kids. And every trust has to be tailored to your individual family needs. So, probate. So this is why a trust is now even more golden than before, is if you have a trust and you have your one house. So one house does not before and not now, has never disqualified you from having Medi-Cal. The difference from before is if you had a house, you qualified for Medi-Cal, and when you passed, both husbands and wife, if there was two, the government could recover what they spent on your Medi-Cal bill once you passed. With an estate, you do not have to, if you have a trust, the new law says that you're protected. So you have the one house, you keep control of your property or assets, and you get to do whatever you need to do. You can use Medi-Cal, and you'll be okay. Additionally, on the new law, and this is still the same thing, the department will not pursue repayment if the surviving spouse, if you were married, there's a child who's 21 years or under. There's also, or if you have somebody that's disabled in the home. There's another rule that's not written here, and that's if you stayed in the home, so you move into your parents' house to take care of them so that they won't go into a nursing home, and you're there for 2 or more years as a child, there are forms, there are things that we can do to help not have to repay that Medi-Cal back. So that's why my golden rule is, we never know what can happen, and we need to keep, I would say, control as long as we can. Your whole estate plan will provide for different situations. Okay, so my next handout is probate, and I'm just going to quickly go over this. And the probate process, with or without a will, you have to go to court. A will is a letter of directions that has to be supervised and approved by the judge. And this is my ridiculously on-point example. Why? Because numbers are very close to what happens. Timelines are very close to what happens. And but this is just a quick recap and a summary of the probate process. So, if there's a criminal activity, you go to criminal court. If there's a divorce, you go to family law. If it's money issues, you go to civil. If you pass away or you need a conservatorship or guardianship, you go to probate court. Now, my first thing, we have a home. It's worth $300,000. It has no equity, and I'll give you a storyline in just a second. And it says $10,000 conservatorship. All right. Joe and Mary Garcia, husband and wife as joint tenants. Our deeds, when we get a deed, it prepares us for death. Why is that? Joe and Mary are married, Joe dies. Joint tenancy means that Mary gets to keep the house without having to go where? To court. Mary dies, Joe keeps the house without having to go where? To court. Both die, kids have to go to court. But what happens if Mary gets a heart attack? They were in the process of a modification or refinance, or they were planning to sell the house and move to the retirement home. What happens? Joint tenancy. And you don't have a power of attorney. You don't have an estate plan. What happens? You end up in court. Probate. You need a conservatorship. Your Honor, can I make decisions over my husband? We were about to sell and he got sick and I can't do anything. They're not letting me sign. I'm a joint tenant. Doesn't matter. Joint tenancy does not provide for incapacity. Husband and wives, we don't have any special powers over each other, not even to make medical decisions now. So no medical, no financial. So if Joe needs to make decisions over Mary, what does he have to do? Go to probate court. How much is a conservatorship start off at? $10,000. $10,000. One of the best things I'm telling my clients now, if you have a college student, what's one of the best things that you can do for them? If they're 18 and they're out of the house, and even though I'm the mom, I cannot make medical decisions. I cannot make financial decisions. If my kid gets in trouble and I need to go move them from a hospital from Michigan back to California, where's my power? Before your kids go to school, make sure that you have powers of attorney over them. Super important. This is the way we organize families. Okay, so with a will, without a will, we go to court. Conservatorships, because our deeds, husbands and wives usually as joint tenancy. We need powers of attorney to keep us away from conservatorships. Now, Joe and Mary had a house and it was paid off. And Sam, their son, says, Mom, Dad, can my family and I move back? We just need a couple months to get back on our feet. And the parents say, yeah, you know what? We've been thinking of remodeling. We'll get a pool for the grandkids. Come on over. It'll be nice to have you home. So Sam is an only child. They pull out their equity from their home. They start remodeling. They have a pool, and we have a housing crash. And the kids and Joe and Mary, they were just so distraught that they passed. And Sam's like, I want to keep the house. This is my family house. This is where I'm going to raise my kids, and that market is going to go back up, and I'm going to be living where I want to live. So Sam goes to court. He has to file a petition. Right now, the petitions cost $465 to court. As soon as we file the petition, we have to publish. The publication is where the Medi-Cal comes in too. If you pass away, if your primary residence is in the city of Los Angeles, we can publish usually for $270. LA County and Orange County, it's more like $600 now, it's like $556, and it depends on the individual cities. San Bernardino, Riverside, Kern County, Tulare. Properties are not worth over there what they're worth here. Why do I have 2,800? If you have a Latin name, like Guadalupe, Fernanda, Gutierrez de Gonzalez, we're at $8,000 to $10,000. I'm not kidding. Smaller counties charge me by the letter. Yeah, smaller counties charge me, it's crazy. Now, so as soon as we file the 465 petition, we have to publish. Why? My clients are like, well, my parents are private, they would not want this. It's by law. The court will not let you continue if you don't publish. What purpose is the publication? To notify all your creditors. Come sue, Joe and Mary have a house. They left it. We have to, by law, notify Franchise Tax Board. Did you owe any taxes to the state of California? We have to notify Medi-Cal. How much did you use in Medi-Cal? So now with a trust, because we don't have to go through the process, there's no notification. Victims Compensation Fund. Did one of your beneficiaries do something? Do they owe restitution? Gotta get it back. And all your other creditors. So that's what the publication is for. So once we publish, we have our court date. Any amendment to the original petition, 465 to the court. Our final accounting, another 465 to the court, and that doesn't include anything that we might have to pay for the CPA, and $230 status report per year. What does that mean? It's kind of like to keep your case open. In 2013, I could close a probate in 8 months without any fights or, one kid or a whole bunch of kids. I could finish a probate in about 8 months. Now the average is about 2 to 3 years. In 2013, what happened? They closed all our probate courts. So we had Pomona, we had Long Beach, we had Santa Monica, Norwalk, all gone. We have downtown LA and Lancaster. So if I pass away in Malibu, can I go to Lancaster? No, I'm out of the area. If I go to El Monte, if I pass away in El Monte, can I go to Lancaster? Pomona? Out of the area, no. How many courts do I have? I have one. I have downtown LA. Super duper duper saturated. It's the only time we're gonna get a court date within 30 days right now is from the petition to the publication, you have 30 days, and that'll be the only 30-day court. Before, I also used to go and file, and they're like, oh, Yvette, you know, you have a hearing in 3 months, and I'm like, you know what, I'll be back, let me check my calendar, and then the next day I'd go choose a different clerk, and then I'd get a shorter date. I can't do that, everything's e-filing now. So all of my tricks that I used to do, I can't do now. It's whatever they give us, and that's what we have to do. So some things have changed. So now, after we publish the court, everything is, so we have the value of the home is 300, we have no equity. Everything in probate is based on the value of the home, not the equity. So the judge will ask, 99.9% of the time now, they're asking for a bond. I can't get away. Before, I would be number 44 on calendar, and I'd be the only one leaving the courtroom without having a bond. I can't think of an argument now where, so it's 99.9% because I still haven't given up hope. But let's say we have Sam, he's the only son. Who's he gonna steal money from? The house has no equity. Bond, ordered. So the bond is, it's a percentage of the value of the home. So here in this example, the bond is approximately $1,300. If we have bank accounts or insurance policies or something that didn't have a beneficiary, that gets thrown into the pot and the bond goes up. And this is per year, so this is money you'll never see again. The probate referee is somebody that the judge orders to come and value the home. In this example, it's about $350. As attorneys, we get paid a statutory fee. So I have an example here for $1 million. On a $300,000, up to $1 million, on the $300,000 home, the attorneys get paid 4% of the first $100,000, $4,000. Then we also get 3% of the next $100,000, another $3,000. And the law provides for 2% of the next $800,000. In this example of $300,000, we only have $100,000 left, so that's $2,000. So the total probate fee for an attorney is $9,000. It says minimum because if there's anything extra that I can do, I can charge my hourly fees, and they're called extraordinary fees, but they're not that extraordinary. And the administrator also gets $9,000. Now, at the bottom, you'll also see that there's a $25 fee. Now, every time I e-file a declaration or anything, the court charges $25. So really quickly, this would all have to go out of pocket. Why? Because there's no equity in the house, there's nothing. So I really try to avoid probate. Aside from trying to avoid probate, one of the reasons is we have family needs. And sometimes the judge, you know, we get 5 minutes with the judge, everything gets done on paper, there's no interaction, they don't know my family, they don't know my needs. Having somebody else make a decision over my family and what has to happen is just, yeah, it's unimaginable. So, other things that I brought, the next things that I brought for you guys are just a little bit tools for you guys. So anytime you get a listing and it is under probate, or we always need to make sure that the people that you guys have in front of you are the people that are authorized to list, to sell, and all that. So the following documents I just included for your reference is the order for probate. So if I say I'm the daughter, I'm Joe and Mary's daughter, I'm in charge, you're gonna say, well, where's your order for probate? You need to be appointed by the judge to be able to do anything. So your order for probate, and a sample of it is right there, and that'll tell you who's in charge. The other thing that you do need to ask for are the letters of administration. That's the second handout. So your escrow company officer will ask you for that. So make sure you have that at the very beginning. You avoid problems and delays at the end. Notice the proposed action. This is my favorite. So when dealing with trusts or regular probate with no trust, it's always as if a client comes in and their parents have a trust and they want to sell, even though they're authorized to sell, I always ask and I always do a notice of proposed action. It just covers everything we do. Hey, we have an intent to sell. Even if we had to sell quickly and it's in a week, And in a week, this is the date we want to sell, this is how much we want to sell for. You put everybody on notice. The whole thing about California is putting people on notice. You can agree to anything, just let people know what's going on. So with a trust or anything as realtors, or if you're going to for probate, this is something that should be in your arsenal of tools of things that need to go out. And it's the notice of proposed action. It just tells everybody in the family who's a legal beneficiary heir that we are planning to sell, okay? And you put a date. There's the certificate of mailings. They're white slips. The person receiving the mail doesn't know that it's registered, but you have, if the judge were to ask, have you proof that you mailed it? You have your little certificate of mailing, also standard. So these are some things that I wanted you to have, because as realtors and dealing with probate and anything, these are things that you should ask for. It'll avoid for delays, it'll make your clients happy, and so that's really good. Another two things for a tidbit of information. If you encounter with your clients, somebody passes away, mom, dad, it doesn't matter. The LA County Assessor is now enforcing a law that they've had on the books for a while. And that's that we have to fill out the death of a real property owner. We have 150 days from the person's passing to submit that to the court. You don't have to change deeds or anything to the Norwalk County Recorder's Office. It's just a document that says this person who owned this property died. We have 150 days. Why? Penalty $10,000. Wow. And then let's say Joe and Mary are passing it to Sam, and Sam's going to get we can do a BOE 58 transfer between parent and child, right? But if we don't do that 150, even though we do the parent and transfer between parent and child, they're going to be reassessed. And it takes a while. Right now, the LA County Assessor Recorder's Office, to deal with all of that stuff, they got a brand new system, and they're backed up. April 2018. Can you imagine? Wow. So if people are, oh my gosh, you can imagine all the different things that I get. So if we put it into a trust, they don't, sometimes when we put our properties into the trust, the assessor, we're not doing anything wrong. We just have to prove up what we did. You know, this trust belongs to me, it's for my benefit. Please don't reassess me. We have 30 days to respond. If we do not respond within 30 days, I think from practice and my understanding, everything gets put in a pile. And if I'm a clerk and I have some time off, I'll go collect from my pile. If you're done within 30 days and you submit everything on time, there's no reassessment. The other thing that's happening is we're selling, you guys sell properties, escrow runs everything, and then the seller, the son, Sam, gets a $20,000 tax bill. And they're like, I already sold the property. Why? Because when you actually sold the property, all the taxes and everything in escrow got paid off, right? And then you sell the property and you're like, oh my gosh, the realtor did something wrong. That's what they think. Or the escrow agent did something wrong. And you're like, no. The triggering event was the sale of the home because the person passed away. We didn't do the death of a real property owner, okay? And now the person that sold the house, the trustee or whoever, the administrator, gets a tax bill because we didn't do it. And they're like, how do you fix it? It's, like I said, it's a mess because the county assessor just got a new system. They're really backed up. But these are things that are happening and are affecting us in our work right now. So those are just those are a couple things that are new. So that rule was that's been in the county assessors for a while, but now they're enforcing it. So you're like, oh, well, this didn't happen 3 years ago, this didn't happen 2 years ago, it's happening now, and it'll just keep you on top of your game. So that's what I have for you. If you have any questions. Yes.
You said penalties if not reported within 150 days. How much is the penalty again?
It starts off at 10,000.
It starts at 10,000.
Yeah, and then additional. So you get the penalty, and then you also get the reassessment. And
how come the reassessments were 30 days and the penalty is 150 days?
No, there are different things. So you get a penalty. So the law says that after 150 days you can get a penalty. Okay, and that's like the 10,000. And like I said, once you prove up that there shouldn't have been a reassessment, we should be able to clear it up. And so that was the 150. And what was the next?
The 30 days, you said there was a 30-day reassessment
Oh,
period.
so when you get anything from the assessor's office, there's nothing 30 days. When you get anything from the assessor's office, you have 30 days to respond. If you don't respond, it doesn't go through the normal course of business, and it can take us up to a year later to try to clear it up.
Any other questions?
You
Yes.
said something really early on too, you said that it has to be an irrevocable trust. What's the difference? I mean, why would it have to be an irrevocable trust? I mean, that was one of the first things you
Okay.
talked about.
Yeah,
The
so
difference
no-
between irrevocable and revocable.
Okay, so actually, with the new change of law, if you have one house, I recommend a revocable. It allows you to maintain control on your property. Before 2017, we couldn't do that. If you have more than one property, you would be disqualified automatically from Medi-Cal. So that's when it would be irrevocable. If you have one house, I would not recommend irrevocable unless you're 92 and you're like my son. Sam takes care of everything anyway. What's it, a revocable trust? You know how when you buy a property, real estate, you get a bundle of rights, everything. So when you have a revocable trust, you keep your same bundle. You know, you can sell, you can buy, you can encumber, anything. When you have an irrevocable trust, it's kind of like you're setting up a family business. So here, Joe and Mary set up the family business, like a corporation, kind of like an LLC, but they're not. And we get its own tax ID number, and then we name Sam as trustee. If Sam gets divorced, can his wife come back? No, because he's only the trustee, not the owner. How about Sam wants to be a first-time home buyer? Will it affect it? His name is on the deed. No, he's not the owner. What if Sam gets in a car accident? No, he's not. So the irrevocable trust takes the part of the bundle of rights. It takes the ownership out of Joe and Mary's name, but it gives them all of the benefit. So the irrevocable trust says Sam and Mary have the benefit for themselves, but Joe and Mary, and Sam the son controls. So if Joe and Mary wanted to sell, Sam would be the one signing the documents for you. Yeah.
Okay.
On the tax situation from the created the irrevocable trust, on the appreciation to the time you're getting the property, the appreciation, what's happening with the income tax thing, that thing.
So I always recommend once, as an attorney, I have a client right now that's really mad at me because when they did their probate, they had to get a realtor. I didn't let them do owner to owner. And even as an attorney, I told the client, as an attorney, I would hire a realtor. I don't do, everybody has their own specialty. So for taxes and anything, there won't be a charge, but you need a CPA. You need a good team of different people, different professionals doing different things to make sure that you have a good estate plan.
Thank you, Yvette.